Welcome to Looking at Legal Stuff. Today we have 9 hearings in a case with a couple where Mama's petitioning the court for visitation after not seeing her child in years due to her alcoholism and homelessness from the breakup of their marriage. She says that despite being sober now, Dad refuses to let her see their son. Dad is furious and says Mama's refusing to take responsibility for her actions, including blaming the demise of their marriage on him, despite the fact that she was the one having an affair. And that's just for starters. Let's see what the commissioner thinks of this mess.
Here.
And Curtis Hart, are you here?
I am.
All right. All right. This is a motion brought by, I believe, Ms. Hart to see the children, or I forget how many right now. So Ms. Hart, do you want to start, and then I'll go to Curtis Hart and let him respond, okay?
Okay, thank you, Your Honor.
And would you speak up just a little bit?
Okay.
There you go.
Okay.
Yep.
So I prepared what I was going to say here. So I take full responsibility for the mistakes that I made. I was at that time unable to process the grief and the loss for my marriage ending and the trauma that I had suffered from the extreme verbal abuse. The abuse and harassment continued after we separated, as the police records show, to the point that I had a complete mental breakdown. And during that time, my drinking had become unmanageable, and I eventually ended up homeless. I do want to address some of the accusations presented in Curtis and Mandy's declarations, which are blanketed with false accusations. I never abused or neglected my son. He had good school attendance and never missed his doctor or dental appointments. There are no police records, nor had I been involved in any criminal activity or illegal drug use. I've made multiple attempts to contact Eric, but was denied every time, as even declared in their declarations. I've been completely alienated from maintaining a loving, stable, consistent, and nurturing relationship with my son, even knowing, as they declared, that Eric had separation issues and was affecting him mentally. On December 23rd of 2019, I filed and served documentation showing I was in compliance with the parenting plan provisions as instructed by Mandy Hart, and she said that they'd let me see Eric for Christmas Eve. Yet again, I was alienated and not even allowed phone calls, as I was told that was not enough. Your Honor, I respectfully ask the court to deny Curtis's proposed parenting plan. I'm currently on state assistance, as you can see from the fee waiver, and I don't have the means to do supervised visits in the facility. And I don't want to mess up any progress Eric has made over the last 2 years. That is why in my proposed temporary order that we begin with every other weekend. I believe that Curtis's proposed plan is nothing more than vindictive, rather than him trying to cooperate with me and do what's best for our son. Curtis is not Eric's full-time physical caretaker. Eric has not been in Curtis's full-time physical care supervision since 2019, as stated on page 3 of Curtis's life's declaration. I've been in stable housing for over a year. I just renewed my 1-year lease last month. I have a 3-year-old daughter, and there's a declaration from her teacher who has been coming into our home once a week for her schooling since we moved in. I've also been in mental health counseling for over a year, twice a week, and I realized that I needed to address my mental health in order to maintain a lifetime of sobriety. Your Honor, I only have my son's best interest at heart. He needs me as mother in his life, and my goal is to have my son live with me rather than his grandparents full-time. I'm in treatment, and I have complied with the previous parenting plan provisions, and I've provided all the documentation showing so per court orders in April 2017. As you can see, no other court orders for modification have been signed by a judge other than the original parenting plan in 2017, and I've complied with Section 4 of that plan, and I respectfully ask that you grant my temporary order.
Mr. Hart?
Yes, Your Honor.
Any response?
Yes. Well, Your Honor, my ex-wife, I was really hoping that she was going to take full responsibility for not being in her son's life for 6 of his 9 years, but it sounds like she's still trying to blame me for leaving the marriage, that she had an affair and moved her boyfriend into the house. I moved out. She very quickly just kept on drinking to the point where I had to take her to court to get a the papers are there. It's a I'm sorry, I'm a bit flustered right at the moment. I had to take her to court to make her stop drinking in front of Eric, and she had him removed by the courts for several weeks. When she got him back, she destroyed every single thing inside of her house, all the glass. She did that in a blackout rage the day she got Eric back from not having him for several weeks because of the drinking issues. After that, there was a contempt of order charge that was levied by the courts because of that drinking incident. And that's why she can't see her son. She's never lost custody. I have to also follow the court order that allows her not to see him. And the ball has been in her court this entire time. She's never filed anything as far as I know. I've never been served anything by anybody. There's a lot of what she just said is just false. And what I'm asking for is I believe in Eric's best interest. She doesn't know Eric. She hasn't seen him since he was about 3 years old, or 4, I guess. Anyways, she hasn't seen him in about 6 years. There's a Christopher Antler on the screen now. I'm going to just keep on talking. And so anyways, she hasn't seen him for about 6 years. She doesn't know him. He doesn't know her. Unsupervised visits is just not in his best interest at all. I believe that there's something called reunification that needs to happen. That she doesn't know him. She has made no strides to be in his life whatsoever. She's sent no Christmas cards, no birthday cards, none of that. And my parenting plan is just asking for basically the same thing she is, only supervised visits, so that he can get used to the person that he doesn't know. And I'd also like to not have every single birthday forever, not with my son. I think that that's a bit much to ask for. And I was also just like to point out that the original parenting plan did give her more than what she's asking for now. And all she had to do was go to court and get rid of the contempt charge. But instead, she wanted to do all this. So my son lives right next door to me. I see him every single day. She doesn't know how much I'm involved with his life because she hasn't been involved with his life one tiny bit in 6 years. And so I'm just going to be repeating myself basically if I keep on going at this point. So,
all right. Thank you.
There you are. Okay.
Ms. Hart, you get a chance to respond.
Like I said, I do take accountability for the things that I did back in 2017. I did make several attempts to contact him, get him Christmas presents, birthday presents, and was denied. Or when they were accepted by his grandmother, they said that they were from somebody else other than me. Curtis was served court documents back in December, December 23rd of 2019, with all my treatment records, clean UAs, everything. And I was 5 months pregnant at the time. I was sober. I had been sober, and it is on court record that those papers were filed, and he was served. It was after that I became homeless. But over this past year, like I had said, I've been in mental health counseling treatment. I've been sober for quite some time now. My 3-year-old daughter, well, she turns 3 tomorrow. She's never seen me intoxicated. So I have changed my life, and I've done all the things that the court required, above and beyond even. So I know that my son is ready to see me, to come home to see me. I heard him on the phone with my mom yesterday saying so, that he wanted to come home and see his mama.
All right. Thank you both. So there was a final parenting plan that was entered on November 22nd, 2017. Issues arose, and in 2018, the court suspended visitation with Ms. Hart. And that order has never been rescinded up until today. Ms. Hart has made some strides in dealing with her issues, and I want to compliment and acknowledge that. She's indicated that she's done an SUD assessment, that she's to do outpatient care. I think she's doing that. She indicates she's been sober for several months. And so now she's come back to court, understandably, to remove the 2018 suspension in order to see her son. I think we need to take a couple steps before we get to that point. And so, Ms. Hart, I'm going to tell you up front that I've been through this process a number of times where a child has not seen a parent for a while, and we have to reintroduce or introduce the child to the parent and do it in a way that's safe. And it's going to take so long, you're probably going to be very frustrated. But I want you to look at the end of the road where you will have a fairly normal relationship with your son. But we need to take some steps to get there. The first step I'm going to do is appoint a guardian ad litem to do an investigation of Ms. Hart, and also just look at the whole living situation for Eric. So I need to do that first. I'm not going to order any kind of contact between Eric and Ms. Hart for at least a month while the guardian ad litem does an investigation. And that's because I'm not sure what that contact looks like. I don't know if telephone calls are appropriate. I don't know if reunification counseling is appropriate. I need assistance from the guardian ad litem in order to determine that. All right. The order that Ms. Hart provided was an order on adequate cause. And I wanted to address that. I'm not sure that at this point, that's the order we want. Let me just person. There we go.
I'm sorry, Your Honor, I can't hear.
Yeah, I just muted somebody.
Thank you.
We may do an order for adequate cause, which would cause you to go to a trial to change the parenting plan from what it was in 2017. But right now, what I see is I'm addressing whether the contempt order of 2018 should remain in effect. And if not, how does that change? I think that's something I do from this docket. And so I'm going to retain everybody for a while, at least until we get a guardian ad litem report, and maybe take some steps to reunite Ms. Hart with Eric. Okay. So the way we appoint a guardian ad litem is we give 3 names. If you know of any of these people, let me know, and we'll see whether they're appropriate to go forward or not. So the individuals are
Heather Paul, David Turnbull, and Ann Hyde.
I didn't hear any of those.
okay. So I'm going to tell you Heather Call. I think it's Kahl. Amy Turnbull and Ann Height. Either of you know any of those? Okay. So I'm going to appoint Heather Call as the guardian ad litem here. All right. I'm going to put this over a month, and that's going to be to April 12th. To give Ms. Call at least some time to meet with you and get started. I don't know that she'll be completed in her investigation, but to get started. In the meantime, nothing's going to change. That contempt order will remain in effect. Ms. Hart, you're not to have contact with Eric until we do this investigation. Okay.
Okay.
Mr. Hart, any questions?
So do I contact Ms. Call, or does Catherine?
She should contact you. In the order that I put together appointing her, I provide your contact information.
Okay.
So she will contact you. Good
All right.
question. Ms. Hart, any questions?
No.
Okay. All right. We'll see you back here on the 12th, and we'll go from there.
Okay. Thank you, Your Honor.
Thank you.
All right. Curtis Hart and Catherine Hart. I see Ms. Hart. I thought I saw Mr. Hart here also. Good morning, Ms. Call.
Morning, Your Honor.
What came up was both parties made a motion to have the county pay the guardian ad litem fee, and they filed financial declarations that, so far as I can tell, does qualify them to have the county pay. So I prepared an order amending the appointment. Let me just write amended on here. That does provide for county pay of the guardian ad litem. Okay.
All right.
Ms. Call, have you had a chance to meet with the parties at all or contact them?
Not yet. We've had contact. They've both returned their questionnaires, their intake forms. I was waiting to move forward more until we had a ruling on this particular issue. So now that I know the answer to that, I'll go ahead and move forward and we'll get things underway. They've both been communicative. They've both returned their paperwork. So I have good reason to think this is going to go well.
Okay. If I set a review on the May 10th, would that be appropriate?
Yes.
Okay. So Ms. Hart, will May 10th work for you to come back?
So, Your Honor.
Okay. So I'll set another review on May 10th at 9 o'clock, and that will be to get an update on the guardian ad litem report. I think there was a request for adequate cause in this case, and I held off on that decision until I got some information from the guardian ad litem. So hopefully by then, or perhaps within another month of that date, I'll be in a position to make a decision. Okay.
I think I can help you out with that. We do, Your Honor, there's a hearing scheduled next Wednesday morning at 9 a.m. and to deal with the filing of the fee issue. And so would that hearing still be necessary on the 19th?
Let me take a look here.
One of the reasons I ask is because I'm actually scheduled to be at a hearing in Clark County as well at the same time. So I'm curious about that.
Tell me again, what does that hearing involve?
This had to do with the fee waiver.
Oh, for the guardian ad litem?
Correct. Yeah, the guardian ad litem.
That can be struck then, if that's all that's on for next week.
Ms. Hart, am I correct in saying that?
That's right.
Okay.
Oh, I see. There, it does show a notice of hearing for the 19th. Well, I've already determined that I will have the county pay the fees. So I've granted your motion, so we don't need to be here on the 19th. Okay.
Okay.
So we'll strike that hearing. We'll be back here on May 10th.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. So let's first call Curtis Hart and Catherine Hart. I think they're both here. And Ms. Call is the guardian ad litem. I think I've set this on for today just to make sure there was contact with Ms. Cole and that we're moving forward on the guardian ad litem report. Ms. Cole, do you want to respond?
Yes, I've been able to do home visits with both parties. I've been up to kiddo's school and met with his teacher. I'd like to bring attention to the court that I found out in my home visit at Dad's house, at Mr. Hart's house, that kiddo is actually not living with Dad. He lives across the street at his grandparents' house. Yesterday, I received third-party information that there's a pretty serious health diagnosis that's been given to Grandma. And so I need to do a little more investigation to make sure that that's accurate and true. I'd also like to, based on the investigation at this point, I'd like to request, I asked Mr. Hart if he'd be willing to submit to a hair follicle test based on some allegations that have been made. He said he would not. So I'd like to ask the court to order that, as well as a mental health assessment. I'm concerned that this diagnosis of Grandma's is going to deeply impact Eric's living situation. So I want to make sure that going forward, if we have to make some living adjustments, that there's a healthy, safe place for him to be. Other than that, Mr. Hart has not provided me any collateral references to speak with. I've kind of just been finding these things on my own. At this point, I'm receiving lots of communication from Miss Catherine Hart and have had interaction with all of her collaterals and have received her tests.
Okay.
Am I frozen? There we go.
No, you're not. I have that your final report is scheduled for June 14th. Is that still a realistic date?
If I could request 2 more weeks to get some test results back and to have time to do a little more investigation regarding the living situation for kiddo, that would be really helpful.
Okay. Mr. Hart, do you want to respond to the request by the JEL that you have a hair follicle test and a mental health evaluation?
I don't mind. I don't mind having a mental health evaluation. I see no reason to have a hair follicle test. Just because she asked me if I wanted to submit. I don't feel like it's necessary. I don't use drugs. I don't have a history of drug use. I don't have a history of drug and alcohol abuse. So there's just no reason for me to do it. If you're going to order it, I suppose I will, but I just don't feel like I need to prove my parenting to the state. I've been involved with Eric, his entire life, not just a third. So, I mean, if you're going to order it, I will. I don't see it necessary. I don't see it being, I don't have money for it. The state doesn't need to spend the money on it. I'm not a drug addict. I've been in my son's life the entire time. So if it's something that you're going to order, then I will, but I don't see it being necessary.
All right. Let me hear from Ms. Hart. Any comment regarding this case?
Just that I've submitted months worth of clean negative UAs. I have absolutely no problem submitting to a hair follicle test. I've definitely been clean and sober for longer than 6 months. And Curtis has used drugs since he was 12. And so I believe that his heavy use of marijuana does contribute to a lot of his anger issues. And I think it would be an excellent idea.
Okay. Sometimes
Ms. Hart hasn't had any contact with me in 6 years, so I'm not really sure what she's talking about.
Your Honor, can I address this?
Sure, go ahead and then I'll make some decisions.
The request that I'm making is not a direct result of Ms. Hart's accusations. I've had multiple interactions with collateral parties who are concerned that drugs have been a factor and that there's very serious issues with anger management and harassment on Mr. Hart's part. This is not coming from one source.
Can I ask who these sources are? Because this is court. This is a public court. I got to know who my accusers are. If she's saying that people are saying that I have anger issues and drug abuse issues, that's something I would very much like to know. Who's Who's
But-
saying that?
I think those individuals will be identified when the report comes out.
Okay.
You on for now. I'm gonna keep working on it over here. You okay with that?
Let me mute this person here. Okay. All right. Sometimes I will order a hair follicle test because we just want to have a level playing field and make sure where we're starting from. And if we're starting from a place of everybody's negative, that's great. But we need to have the test in order to determine that. So I think it makes sense to do that. So I am going to order a hair follicle test. I am going to order a mental health evaluation. You can do that either at Columbia Wellness, I believe, or Core Health, and you can talk to them about having that completed. I will extend the time for Ms. Call to provide her final report to June 28th. I'm going to strike the hearing on June 14th. And if there's any issues that come up, you can always note a hearing in front of the court. But in the absence of that, our next time together then will be on June 28th, and we'll review the report by Ms. Call.
Thank you.
So
Your
am I
Honor.
going to get like a court order for that hair follicle test? And do I have to pay for that, or what's going on with that exactly?
That will be at your cost. I will do a bench order for it. It'll be available by tomorrow afternoon if you want to see the order.
So is that something I can fill out a fee waiver for, since it's being ordered on me?
I think you'd have to talk to the entity that does it. I think, well, I'm not sure where you're going to go to have that done. You'll have to talk to them to see if there's a way to waive that fee. I don't think I can do county pay on that.
Even
Your
though
Honor,
you're ordering it, you can't do county pay, even though it's court order from the county?
Yes. Ms. Call.
Yes, Your Honor. I think it should also be noted that Mr. Hart told me in our interview that he and his wife, Amanda Hart, own a local spa in Kelso, and that is where he works and receives his income from. So while we were, and
I don't receive income from there. That's not true. I never said
Let's let Ms. Call finish, okay? And then I'll let you respond.
when I asked Mr. Hart how he supports himself and his son, his response was the income from the spa that he and his wife own together, and that he works for her and works there. I only give that information because this is now a county pay case, and he is asking for more county pay support.
Yes. That's because I qualify for that. I filled out the paperwork and I qualify. Therefore, there you go. Since you're bringing it up.
You'll need to talk to the entity that's going to do the test to see if there's a way to get the fees waived on it.
All right.
All right. Thank you. We'll see you back here on June 28th.
Thank you, Your Honor.
Thank you.
Now, I think we have a few matters. I think I'll start with Curtis Hart and Catherine Hart. If you folks are able to unmute and turn your cameras on. Okay, I'm just going to stand up and stretch my legs for a minute. Hopefully you all can still hear me a little bit. This is 17-3-00-46408. Believe I saw Mr. Hart. Are you present and can you hear the court?
Yes.
Okay. And then Catherine Hart, are you present?
Yes.
Okay. And Ms. Hart, I'm having a little difficulty hearing you, so you might need to either move closer to a microphone or speak up a bit.
Okay.
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 So let me get into that digital file quickly.
I did provide a bench copy of the report. Should be there for you.
Oh, perfect. Okay, let me grab that. This also is a case with a lengthy history. So much like before, if I get something wrong, please correct me. I take no ego in this. I hopefully get it right, but with these longer cases, I know you all have been involved in this case for a long time. I am not, let me look through one more time. Hold on.
I can also email it to your judicial assistant real quick if you'd like.
Yeah, let's see. I don't have a bench copy. I
sent one to you through the clerk's office, but can I have the email address for your judicial assistant?
yes, you can send it to Sylvia. And I don't have it memorized yet. So let me pull it up here real quick.
Yeah.
Okay. So it will be WIRKKALAS@cowlitz.gov.
Thank you for your patience, Your Honor.
Oh my gosh, of course. And it looks to me like while you're doing that, that what we are here on is review of the report. Does that sound correct to the parties?
Yes.
It looks like, oh, go ahead.
I was just saying yes.
Okay. And then it looks like at the last hearing on May 10th, there was an order for hair follicle and mental health testing for father. We can maybe talk about whether that's been done. And then the report, the GAL report review date was set for today. So those are kind of the two things on my list. Is there anything else the parties were thinking we would accomplish today that I haven't mentioned?
No, Your Honor.
Nope.
Okay. So let's start, while I'm waiting for that report to come in, let's start with an update on hair follicle testing and mental health evaluation. So I'll turn to you, sir, Mr. Hart, and let me know where you're at with that.
I got both of those accomplished.
Okay.
I got the results for the hair follicle test turned in. I haven't gotten the results from the mental health evaluation, but they didn't recommend any counseling or give me any diagnoses.
Okay. And I didn't think the records that were submitted to me first were from Ms. Hart. Showing full compliance for the month of May with your obligations, and also fully negative testing. Does that sound right to you, Ms. Hart?
Yes.
Yeah, thank you for submitting that. So I think, sir, I certainly will take your word that you have accomplished those things. But the court will need some sort of evidence similar to what Ms. Hart has submitted.
I'm just waiting for the ROI to sign to turn in so that they can send it over there.
Got
Yes.
it. Okay.
Your Honor, I should let you know, he did send me the results of his hair follicle test. He needs a new ROI for the mental health assessment. So I'll be sending that to him today so he can get those shared as well.
Got it. Okay. And let's see. So on that, I guess we could just do, are you guys set for trial yet?
No.
Is this going to trial?
Well, I'm going way, way back. Give me just a minute here.
That's the first time I've heard of that.
Yeah, I hadn't heard that we would require a trial.
Oh, okay.
Neither one of us want to go to trial.
No.
Okay. So the last, when this came back in front of the court after long history, it looks like back in March, when the GAL was appointed, one of the parties had filed an order for adequate cause. The court said, we're not gonna address that right now. First, we're gonna address contempt, and then they assigned the GAL. So I don't actually see, and you guys can help me out here. If there's still, it seems like out in the ether somewhere, there still is this motion for adequate cause that hasn't been addressed since March. So maybe the folks can fill me in a little bit on what the folks are wanting the court to decide.
Today, when I turned in my medical documents last week, the clerk told me that none of that was going to be happening today. Today was just the GAL report review.
Right.
And so today I'm hoping that after I had a chance to read the entire report from Heather, that I asked the court that adopt her recommendation on that report.
So you both have had a chance to review the report, is that correct?
Yes, I've read the whole report.
Well, I guess what I'm trying to get at and is obviously we're going to discuss the GL report. That's why we're here today. But I'm just trying to make sure I understand what the ultimate goal is, because the reason a GAL was assigned is because someone filed a motion for adequate cause that hasn't yet been ruled on. And my assumption is that's because someone wants to change something that was ordered previously. So help me out there a little bit.
Okay, and I'm the one that filed the motion for adequate cause, and this is all kind of confusing to me, as so you know, because me and Mr. Hart were in complete disagreement with both of our proposed parenting plans that we filed at that time. Then the court appointed the GAL because we were in complete disagreement. And so she did her report, and the clerk told me that I was probably just going to need to refile a new proposed parenting plan once all this was done. And I think with the GAL's recommendations, all the visitation and everything, it is going to be a process, which I am in agreement with. So I think at this time, the papers that I filed way back when at the beginning of the year are just kind of, they aren't pertinent right now.
Okay. That helps me out a lot. I appreciate that. So I'll turn to you, Mr. Hart. Have you had a chance, I'm just waiting for that report to come in still, but have you had a chance to review the GAL report and recommendations?
I do. I agree with pretty much all the recommendations except for she recommended a non-professional person for the visitations, for the supervising the visitations, and I don't know anybody. She said she wanted both parents to issue 3 names. The only person that's associated with my ex-wife that I trust at all is her mom, and she lives in Las Vegas. I don't know anybody around here that's willing to do that. My parents aren't willing to be the supervisors for her visitation. And I don't know anybody that's willing to put in that kind of time and responsibility. And that's why I asked that, it'd be under a professional setting. And that's pretty much it. There's a couple of points in the order that, or in the report that are just like not factually correct, but at the end of the day, it's not going to really change anything, because I've never said that I didn't want Catherine to not see her son. I just wanted it to be under supervision and be safe for Eric. And so that's pretty much it.
Okay.
I would like to know when she's going to be, if ever, like at all financially responsible for him. She's not paid any child support. She's never bought him any clothes. She doesn't financially support him in any way, shape, or form. I know that she's not legally bound to, by means of like any type of court orders to take away, like driving privileges or anything like that. But it just like, I know that it was part of the original contempt charge that she get caught up on that, and she just never has. And so like, that is kind of a concern. But mostly my biggest concern is I believe that it needs to be in a place that we can just pay, so I can trust the people, because I just don't trust anybody that has anything to do with her except for her mom.
Can I
That's
speak
where
to that
Eric is
for a
now.
moment? Your Honor?
Yes, absolutely. So, sir, I'm going to turn to Ms. Call here. Go ahead.
Yeah, I can certainly appreciate where Mr. Hart is coming from on that point. My concern around it is my interest, and I believe the best interest of the child, is starting to reconnect with his biological mother. Mr. Hart is not invalid in requesting that. The issue becomes resources. Do we have the resources available? I actually agree that Ms. Hart should have to catch up on her child support payment. And I understand where Mr. Hart's coming from in that request. I'm not sure that those resources are available, and to withhold even more visitation due to that lack of resource feels concerning to me. It's a county pay case at this point. We have both parents who are officially unemployed at this moment in time. And so preventing the child from having contact visitation with their mother for that purpose, I was trying to avoid that situation. That's where I'm at with that suggestion.
I'm not suggesting that we like not let her see Eric because of the unpaid child support, because like she's never paid child support, so I'm like completely used to that. I was just bringing that up, but the main thing is the supervised visits, because I just don't trust any of her associates, and I don't know enough people around here that have that kind of time or are willing. I don't hang out with any of the same people for the most part that I did when I knew her. So that's pretty much it. But the whole thing about I'm not trying to stop her from seeing Eric because of the lack of child support. I was just wondering if that's ever going to be. I was just bringing it up. It doesn't really matter though.
Yes, it sounds like your primary question, or I guess question, probably doesn't really sound like it's an objection, but your primary question about the GAL report surrounds who would do the supervised visitation. Is that?
That's my primary concern about it. Like, I have some objections to the facts that she listed down. Like, I was misquoted a few times, but that's not going to change the outcome of anything. So it doesn't really matter. Like, I don't need to bring that up.
Right. And you probably heard me say to other folks, I'm more concerned with any objections or agreements to the recommendations. I certainly understand there's at least two sides to every story. I get that.
Yeah, I have no objections whatsoever to like the timeline. I think that's all great.
Okay. Well, Ms.
It's
Call,
just the supervised visit thing. Sorry about that. Sorry to keep cutting you off.
and who does the supervised visits? And you're saying you don't know anyone who could do it.
I don't know anybody that is willing to do supervised visits for Catherine, because my parents aren't. They would be the only people that I would know that's willing to do that kind of thing at this point in time. But they're not trying to put up with that stress. They're just not willing to do that. And yeah, I don't trust any of Catherine's associates.
Okay. Well, Ms. Call, I'll turn it over to you. I still don't have that report, but I'm sure it's making its way through the printer system and into the courtroom, but I'll have you go ahead.
Like, I know before her, like one of Eric's teachers before had offered to be like to do the supervision. There might have been a school counselor. I can't remember.
Okay.
Like, I don't necessarily need her to pay for it. I don't care if it's like expensive or the cheapest place in town. I just need it to be somewhere that somebody that I can trust.
Okay. Thank you, sir, for your input. Okay, Ms. Call, go ahead.
Yeah, I confess. So kiddo actually does live with Mr. Hart's parents. So I do confess that my hope was that would be a situation where we could have that occur. I believe Mr. Hart in saying, and again, I don't expect Mr. Hart to carry a lot of trust for Ms. Hart at this point in time. But I'm trying to think through a quick solution to this. If it really is true that there's absolutely nobody in town who could handle a non-professional supervised visit, then perhaps we do have to ask for a supervised visit. I'm not a professionally supervised visit. I'm not comfortable, mostly for Eric's sake, of putting him in a situation where he needs to now be with somebody he doesn't know at this point in time, or somebody who we have a long history of needing to rebuild trust with. and rebuild a relationship with. And so there does need to be supervision. In my opinion, there needs to be supervision of some kind, mostly for Eric's benefit, to help him be as comfortable as possible as he rebuilds this relationship. So if it's really true that there's absolutely no one, if Miss Hart has a solution to this issue and Mr. Hart can agree to somebody around, I think that would be my number one hope, that they could come to an agreement. If that is absolutely impossible and there's just no way forward, I think that we do have to go to a professional supervisor.
Yeah. Miss Hart, let me turn it over to you. Do you have proposals for folks? And obviously Mr. Hart would need to agree, that could be there for supervised visitation. Otherwise, as you heard, and I don't know any other solutions beyond professionally supervised visitation, which does cost some money.
Well, I just got this report, last night when it was emailed to me, so I haven't had a chance to reach out to anybody yet. I would have to say that I don't associate with a lot of people. So I haven't gotten that far. Right now, I was just kind of focused on getting these phone calls started. I do have my best friend, Melissa Tavares, who would be willing to do the visits. Mr. Hart knows her very well. She's been my best friend since I was 10. She's a legal assistant down in Vancouver, but would be able to make herself available to do the visits.
Mr. Hart, do you know that name?
I do know Melissa. I don't trust her at this point in time.
Okay. That's fine. Here's kind of my thought with this. I think what I'd like to do today, and I'm not trying to cut parties off, please, we'll continue discussions. My thought is, since I don't have the report yet to look at anyway, and it sounds like maybe the parties could use a little additional time to come up with a potential solution for supervised visitation. What if we set this over just 2 weeks? I would certainly note that the GAL report has been filed in a timely manner. And then we'd come back in 2 weeks where maybe we all have a little time to pick our brains about a potential solution. I'll say the catch-all, if we don't, is that it's going to be supervised visitation. And if there isn't money for that, unfortunately, I wish I had a solution to that, but I don't.
Can I share? I'm just hearing from a fellow GAL some information that I personally didn't have, which is that Parents Place, while their availability is limited, they charge $25 an hour, which is very, very low. And then Beth Fellows actually can do supervised visitation through her company, and she charges $45 an hour. So there are reasonably priced options should we need to go that route.
Okay.
But Your Honor, if you're comfortable giving Ms. Hart immediate digital visitation while we work on this, I'd really like that for both people involved.
Okay. Let's, Mr. Hart, what is your take on it? Well, first, Ms. Hart, Mr. and Mrs. Hart, actually, you both will have to be a part of this. Do you both have the tech capabilities to engage in Zoom or FaceTime visits between Ms. Hart and kiddo?
Yes.
Yes.
And Mr. Hart, is that something you would be comfortable with?
Facilitating that once he gets back home. Yes.
Okay. When could I'd like to do a bench order that does allow that. How would the parties like that to be crafted?
Well, right now, Eric is with my mom in Nevada, and he will be for 3 weeks.
Okay.
He has been asking her to be able to text me, and he wants to video chat with me, but we were just kind of waiting until court today, hoping that it would be a thing that the court would allow. And so I would ask that the court allow the visitation, electronic communication start immediately, like Ms. Call asked for as well.
Mr. Hart has stated that he trusts Ms. Smith, Ms. Hart's mother, so much so that he sent his son to go stay with her for the next 3 weeks. So I don't feel like
after reading the GAL report, I take that statement back, actually. Just to throw that out there. She lied to me several times about certain statements that were proven to be incorrect in the GAL report, but I would just much rather prefer that he be home with his whole entire family before that starts, so he can be with his Grammy and Papa. He's only with Grandma Alice, a few times for a few weeks out of the entire year. And I feel like it would just be much better served for him if he was here with everybody else to just unpack all that.
Well, here's what I'm going to do. I am going to issue a bench order that I guess, Mr. Hart, here's what I think about. Obviously, you trust this woman enough to have your child. So I believe I can more likely than not trust her enough to supervise electronic communication with Ms. Hart. Is there no electronic communication occurring?
That's
There
correct.
hasn't been any type of communication whatsoever.
Yeah. So let's do this. Let's just kind of baby step this in a little bit. Let's say twice a week. I don't think I want to go into texting at this point. I think that can get a little back and forth and maybe difficult for kiddo to receive tone of voice and face and that sort of thing. So let's say starting now, and I'll do a bench order 2 times a week, up to 30-minute video calls with mom are allowed.
Your Honor, also by using the Our Family Wizard app,
Okay.
I could monitor all of those conversations and see all communication.
Oh,
That's the beauty of that app. So it's not just Miss Hart and Eric communicating or Miss Hart and her mother communicating about Eric. It's actually, if Miss Hart is required to only communicate with Eric through that app,
yeah.
it's all it may help Mr. Hart feel some security in that all of that is being recorded and kept somewhere.
Okay. And forgive me for not being super knowledgeable about Our Family Wizard. Does that allow video calls or is it just at texting? Oh, it does.
Yeah. Mm-hmm.
That's great. Okay. Perfect. So let's do that. I will include that the communication will go through Our Family Wizard. And then if the folks want to set this for 2 weeks out to finish our review of the GAL report, my thought is if Mr. Hart, you are having heartburn about any of the communication that has taken place, we will also address that on our 2-week check-in. So that would be July 12th. I believe, if I got my dates right. Yeah. Well,
I'm on the Clark County docket that morning at 9 a.m.
Oh, okay. Would July 19 work?
Yes.
Sort of.
Yeah, I have another case that morning, but I think it may be the same docket. I'm still waiting to find out, but yes.
Okay. And Mr. Hart, Mrs. Hart, will that work for you July 19th? So that'll put us 3 weeks out.
Oh, yeah, that should work.
Okay. Okay. And so I'll just note for today's record, report is timely filed. I just need a chance to review it. I've listened to the parties' discussions about any questions or concerns they have about the report. And then Mr. Hart, I still believe if you can keep working with Ms. Call on the ROI and mental health records and that sort of thing, that will be helpful before July 19th as well.
So does the report, does that get amended once the mental health records come back? Because she says in the report that she recommends certain things that wasn't recommended by the professional. So I'm not sure how that gets fixed in the official report that's going to the court, because she's not a mental health counselor. She made recommendations as if she was, and if she knew the results of what they would be, and that they turned out not to be that way.
I haven't been provided with the results of your mental health assessment, so I didn't have that as I was writing those recommendations.
You did assume in your paperwork.
Well, sir, I'm gonna stop you there, sir. What I'm gonna say is that the GAL and the court will rely upon mental health professionals for our final recommendations and orders. What you have right now, and often what courts do, is say, hey, like, we're not sure what's going on here. Based on some evidence we have, we think maybe this, but we would like a professional to weigh in. That's what's happened here. So this isn't a situation where Ms. Call is trying to be a mental health provider. This is a situation where she is asking for input to this court and to herself from a mental health provider. So, sir, the steps that you're taking, the report that you're getting, assuming it says what you say it says, perhaps there isn't further treatment to undergo, but we have yet to see that. So that's what we're waiting for.
Okay.
Okay, does that help?
I mean, I guess.
All right. Well, we'll see the folks back here on July 19th, and we'll address all of these issues again based on new information. Okay.
Okay, thank you very much.
All right, Mrs. Hart, Mr. Hart, you're free to log out. Okay, you all should get a notice that this is now being live streamed as per our open court policies. Okay.
Is the court aware that somebody's out there is recording these and putting them on YouTube under a different channel? That's totally happening because somebody asked my mom about the things that Heather Call was saying about her a couple weeks ago. And when we asked her how she knew, because I thought it was just under Zoom, she said that my cousin had watched it on YouTube under, I can't remember what the channel's called, but it's definitely not the court's channel. And they're recording all of Cowlitz County's courts and putting them on the YouTube.
I do. So if you want to reach out with those concerns to court admin, I'm sure they'd be happy to hear them. All I can tell you is per our open court policies, certain dockets right now have to be live streamed on our YouTube court page because the court doors are locked for certain dockets. We do take them down fairly quickly, but obviously we can't control what happens with them once they're on YouTube. But if you have specific concerns about that, you can reach out to court admin.
Oh, okay.
Okay, it's above my pay grade to make those decisions, but if you do have concerns, please reach out. Okay, Ms. Call, I'm going to send it back to you. I didn't mean to interrupt you.
No, that's just fine. It's no problem at all. Those are my main concerns at this point. Watching them kind of get to know each other and have very fun, playful conversations has been a very positive thing. I know Ms. Hart is anxious to get to in-person visitation. We talked about that a little bit. I still want to continue with the recommendation that we use a timeline and a bracketed a scaffolding system to get her there. She's doing all the right things. Her tests are still coming in. But I think giving Eric that time to sort of, especially as he's transitioning back home after being away at a grandparent's for quite a few weeks, I think it'll be good to kind of give him that transition time. We all involved in this case know that Eric needs gentle, slow transitions. Fast, abrupt transitions could have a pretty negative impact, I think, given his history. And so allowing those things to happen at a slow rate of pace, while I know might be it might feel tedious, I think will be definitely important. My main concern is that collateral witnesses that have spoken with me, grandparents, in our last hearing, Mr. Hart stated that there was no one in Ms. Hart's world who he would trust, even people who he's known for years and years and stated to trust in the past to help with visitation. I just have concerns about those things being blocked.
Okay. And I'm just looking here. Are you, Ms. Call, at this point recommending that we do any sort of ramp up of visitation, or kind of status quo for another few weeks and set a review date?
I think status quo for another few weeks, and that's not because of behavior on Ms. Hart's part. I think that has to do with giving kiddo the time to adjust to being back home. I think there's going to be some summer school this summer. I think coming back and having a transitions to Eric need to happen at a certain pace. And I think giving him time to do that slowly is a good recommendation to have.
Okay. And then I just, and again, in going through the, lengthy history of this case, I just want to make sure, and I may have missed it. I know back in May, Commissioner Nelson had ordered hair follicle test, mental health eval for father. Is that something that we're still waiting on, or should I have that?
His hair follicle test came back clean. I'm not sure if he filed it with the court or not. He did send me a copy of that. He also had a mental health evaluation, which he has stated to me came back with no concerns and no recommendations. I have yet to see a document from the facility in which he had that done. I don't believe he's filed anything with the court yet. If I'm wrong about that, I'm happy to own that, but I don't believe anything's been filed in that regard.
Okay. So here's what I'm thinking. I know what we're working towards is creating some permanency for both of you. And that is my ultimate goal, is not just to have you come back for reviews and make changes, but ultimately the goal is to get you guys to a point where we're at a kind of leveling off period where we think that there's some parenting decisions we can make and put in place, and father has some finality and mother has some finality and kiddo has some finality. So that is my goal here. I don't think we're quite there yet. So I think what we should do is set another review date, check in about video visitation again, since that's just been going on for 2 weeks. And like Ms. Call stated, kiddo coming back, entering school, getting back in a routine. And then Mr. Hart, at that next review, I would like to have some either file it under seal with the court or provide to Ms. Call the mental health evaluation, just so there's.
I've signed her release that she sent me immediately upon getting it.
Okay.
And sent it back to her. I asked her to let me know when she got it, and she let me know that I wasn't paying her bill anymore and that she was out of hours for me.
Right.
So I'm not sure if the county pays her less.
Right. So what I'm asking for the next review is that you have signed that release of information.
Yes.
So if you have the mental health evaluation.
I don't.
Okay.
I
So
don't.
I'm gonna put a little bit of burden on you just to get a copy of that from the provider and get it to Ms. Call. Okay.
Okay. Is that not the signing the release that she sent me? Does that not cover it? Or is it just because they probably haven't done that yet? I can call and ask them if that's what's going on.
So I'm today asking you to get a copy of that eval and either file it under seal with the court. Because I'm not going to send a request I'm not going to track down a mental health eval. So you would file it under seal with the court. There's a cover sheet called sealed personal healthcare records. Okay. File that with the court if you want to get it to me. The other option I'm giving you by our next review date is just to get a copy of it to Ms. Call. So either one will work fine for me for the next review. Okay. How far out are we thinking?
I think it depends on how quickly we get that mental health evaluation. It seems like if it's been done and it's been done for a while, it should come back pretty quickly. One of the things I'd really like to address, Your Honor, if we're able, is can we have some expectation from Mr. Hart that he can provide somebody who he would feel comfortable doing some supervised visitation with? I know he's really hesitant about anybody in Ms. Hart's world, but I'd like to have a plan in place so that we can move towards that.
Yeah. I think that is a good plan. And Mr. Hart, I don't want to put you on the spot today, but I do think hold on one sec, Mr. Hart. The next ramp up for visitation is going to be some sort of supervised in-person visitation. So my other homework piece for you is by our next review date to have brainstormed some folks that you would be comfortable with doing that. There is supervised visitation, but that costs money. And I think if the parties have a person that's willing to do it, I think you both are going to be happier.
I have a statement about that. I've thought about that this entire 3 weeks. Anybody that has ever, since Miss Hart has been out of Eric's life, anybody that has ever advocated that I ignore the court's order and just let her see him again and let them come back, because the court order was that they have no contact. Right. That was okay. And everybody in her life, from Melissa, her cousin Tori, the only people that are in her life that I still trust is her brother Michael, Eric's aunt that is married to her brother Michael, and her mom. They all live in Nevada. I don't hang out with anybody that I used to hang out with when I was married to Catherine, because it's not the same person. And
Sir, hold
I
on.
don't know anybody.
Sir.
I don't know anybody that's willing, and that's why
Sir,
that's why I asked for the supervised visit with the professional, because I don't know anybody that's willing to, and I don't, and
Okay,
I
sir.
can't trust anybody that's sorry.
Mr. Hart, stop talking. I am trying to talk to you. Okay.
My phone's going off. I didn't hear you. Sorry. I'm very sorry.
So here's the deal. It doesn't have to be someone that knows the both of you. If you want to give me a proposal of someone you know that you would be comfortable with, let's start talking about those names. I'm asking you to brainstorm some of those names. Otherwise, I feel like my hands are tied. We'll do supervised visitation, but you'll be paying that cost, because I do think you are the roadblock to that right now.
Okay.
So the next review date, let's set, are folks comfortable with 2 weeks out, or do they want 3 weeks out?
I will be out of town the 25th through the 28th.
Okay.
Other than that, I'm comfortable with the second. I'm pretty booked up, but beyond that, I can be open. The 9th might be perfect.
Yeah, let's do August 9th, which is 3 weeks out, if that works for the parties. And, my other thought is, I think we're initially here on an adequate cause motion that's got to get ruled on eventually. And we'll have to decide the permanent parenting plan. This could be a case that we potentially send to mediation if we find that we're at a roadblock here. So Mr. Hart, I just really encourage you to rack your brain about folks that you would be comfortable with in that role initially. So if not, I only have so many tools in my toolbox to offer. And if the parties aren't going to agree on it, then ultimately I eventually have to make a decision about supervised visitation and who pays for it. Okay. I don't know. Mr. Hart, did you?
Yeah.
Okay.
My internet's not working.
Okay, might have frozen. Do the parties have any questions for me about the expectations of what the court will have received by August 9th?
I don't, Your Honor. I do have one thing I wanted to bring up to the court though today.
Okay.
So we were requested to sign up for the Our Family Wizard app.
Yes.
And I did that 3 weeks ago. And Eric and I have been talking for 3 weeks now on the video chats, but I haven't found that Curtis has signed up for the Our Family Wizard yet. And I contacted their customer service yesterday just to make sure I had provided the correct email and everything for him. And they said that they had sent him an invitation email, but they have not received any paperwork or anything from him yet to get that started up on his end. And I want to make sure Eric flew home yesterday evening. And I want to make sure that our phone calls, our video chats are going to continue as they have been now that he's back home. And a concern with that is I understand Curtis had his mom block me on Facebook. And so I have no way to communicate with his grandparents that he actually lives with. And so I want to know what the plan is going to be for that, so we can keep our videos going.
My mom has had the same number for 20, 30 years. Well, Catherine still should have.
I wouldn't know that.
Yeah, just hold on a second, folks. We're going to talk through me, not to each other. So, right. Mr. Hart, just kind of step by step, are you, do you still have an invitation link to Our Family Wizard?
I do, and I just don't have money for it. We wanted a whole year's worth of payment up front, and I don't have money for it. I can totally, if like whatever the court tells me to do, I'm 100% gonna do it. I'm not gonna be trying to get contempt or not follow the court's orders. Like my mom has the same phone number. Like we have Zoom. There's plenty of ways. She does not need to have access to my mom's Facebook and everything that my mom.
I'm not worried about Facebook.
Yeah, like I'm not gonna be a burden to their communication at all. Like I've hoped that she has been taking the steps that she's taken for this entire time because of the detriment to my son that it's been taken.
Sir,
Like,
Right.
so she can just call or text.
Okay, so sir, what we're asking you here today is how are video communications going to continue now that kiddo is back?
We can just do Zoom.
Your Honor, can I?
Yes, go ahead, Ms. Call.
Yeah, so Mr. Hart, there is a fee waiver that you can apply for, which is actually how Miss Hart got the app because she was in the same situation. So if you go into that invite that they sent you, there should be information regarding a fee waiver so that you can present your financials and get the app without cost so that you can. I still believe the best communication between these two people would be through that app where it's recorded. We can see everything. They can calendar talks.
Yes.
Yeah, when I was originally
Hold
told
on,
to like,
Mr.
get
Hart.
that, I just.
Mr. Hart,
Sorry.
Mr. Hart, hold on. Okay. The order in the court file is that you folks use Our Family Wizard. We're not switching to Zoom. It doesn't have the same safeguards. Our Family Wizard is used by family law courts across the country for very specific reasons because of those safeguards and checks. So the order does require Our Family Wizard. So whoever is with kiddo that's going to be involved in those video contacts needs to have Our Family Wizard.
Okay. I had
And
just tried to get it by myself, like through the app store when you guys originally told me, and that's where it showed up with the fee. Like I didn't, so that's why that happened. I thought the invitation was being sent like automatically from the company because I started trying to sign up, and then when it asked for the fee, I was just like, oh.
And I want to be clear, I don't want to see this whole week go by and there isn't video visitation because there's talk about I couldn't get the app and I want that needs to be a priority. I don't want those video communications to drop off this week because of technology. So make that a priority once you log off today and get that going. I will review that at our next hearing. Go ahead.
What days was she talking? Like what it's 2 days a week, right? I just want to know which days like we can, is that appropriate to discuss that here to make sure it happens? Like, because it doesn't really matter.
Ms. Hart, how were you scheduling those when kiddo was away?
It was kind of changing a little bit just because of Ms. Call's schedule at the time. But Tuesdays and Fridays at 2. At least for now until school resumes or he starts his summer classes or whatever he has going on there. So Tuesdays and Fridays at 2 via Zoom because Our Family Wizard does not have a video chat option. So that's why we had to go to Zoom. So I have that all set up. And I can somehow get Curtis the meeting ID and such that he needs to be able to log on if he wants to do Friday at 2.
I see. So you're using Our Family Wizard to schedule the times and then switching over to Zoom for the actual calls.
Right. So all the scheduling and messaging, any sort of other communication other than the video chats between Eric and I, any communication between Curtis and I, or even his parents need to be over that app.
Okay.
And it's free for family members to join in on it. So once Curtis gets his fee waiver approved, it takes 3 to 5 business days to get that done and approved. But once he gets that done, then we can add his parents or whoever else that needs to be on it. They can be on it as well, so they can see scheduling and all the cool features that it has.
Okay. So so Mr. Hart, it sounds like you know what you need to do now to get Our Family Wizard downloaded so you can resume those video communications this week. It doesn't need to be Tuesday and Friday, but it does need to be something that all the parties can agree to time-wise and up to 2 times a week. I'm going to set August 9th for the review of video visitation, mental health evaluation, review, and then we'll start talking about the plan from there as far as increasing supervised visitation if we can think of someone. What I will say though is Ms. Cole or Ms. Hart or even Mr. Hart, if we run into issues where there's because of someone's lack of downloading an app or communicating, if we are not having video visitation for a whole week, I will hear this on next week's docket. So I think what I'll just do is, Ms. Call, if you get wind that this is an issue, I will have my judicial assistant reach out to Ms. Hart and Mr. Hart and have you guys on next week to address that.
And Your Honor, because that fee waiver takes 3 to 5 days, I'm happy to help mediate that conversation. If the parties want to communicate, send me dates that times they're available, I'm happy to mediate that until we get the app in place. Because I believe Mr. Hart when he says if he just needs the time to get that set up. I believe him. I know that he'll do that. So.
Great. I appreciate that. So Mr. Hart, you have a resource with Ms. Call to help arrange that for this week. And then hopefully the fee waiver will be in place.
Okay.
Okay. Anything else right now? Otherwise, we'll see you guys back on August 9th at 9 a.m.
Okay, thank you, Your Honor.
This is number 2 on our docket, 17-300-46408. Do I have Curtis Hart and Catherine Hart?
Yes.
Okay. Good morning, folks. Let me just jump into the digital file here. So by my notes, when we were here last, we set this review to see how visitation was going. We wanted the mental health evaluation to come in, and then just see if there were other issues that were popping up for the parties as we were making some of these adjustments to visitation.
Yes.
Go ahead, Mr. Hart.
The visitation seems to be going well. Eric has had a little bit of attitude. We have him signed up for counseling. He had his intake last week or this week. He had his intake last week. The counseling sessions are supposed to be via Zoom, and so I'm just waiting for the counselor scheduler to call to make that appointment.
Okay. And then I did get the mental health evaluation that was filed. Ms. Call, did you receive that also?
I did, yes.
Okay, and it looks like we're fully compliant there. I don't have any concerns. Ms. Call, what's your position on compliance with that?
I have no concerns around compliance. I wanted to address a couple other things that were in my recommendations if we have a chance, Your Honor. But I mean, in terms of compliance, I think everybody's doing really, really well.
Okay, so Mr. Hart, I'll find that you are compliant with the mental health evaluation component that we were to review. And I'll turn it over, Ms. Call first. Ms. Hart, I will come to you for input as well. But Ms. Call, go ahead.
One of the concerns that I bring up in the report is regarding the fact that kiddo actually does in fact live with his grandparents across the street at this point in time. And grandma is being tested for or is in the process of being tested for Alzheimer's. And there have been a number of reported falls and some issues with memory. And so I would like to address a plan for kiddo should grandma and grandpa be unable to take care of him the way that they have been to this point. One of the recommendations I put in the report was to receive information regarding that testing and kind of what's going on with her medical conditions, just to ensure that, because at this point in time, Eric actually doesn't have a bedroom or a place, at least during my period of time within the investigation, didn't have a bedroom or a place to sleep at Mr. Hart's house. And I know there was concern around safety for some of the other children with some of kiddo's stuff that he's got going on. So I just wanted to address that and kind of hear what a plan was for that and how we can address that issue.
And I do see that in your recommendation that there should be an ROI signed so we can get a copy of that assessment. Mr. Hart, first I'll hear from you on that. Do you have any objection to that? I think the court understands Ms. Call's position and certainly is inclined to require that. What's your position?
I mean, my position is whatever the court orders is what it is. My mom's falls, like most of the falling is just because of stuff being on the ground.
Mm-hmm.
So I mean, like that's mainly it. It's just like a rug in the wrong spot. She tripped on a transition at one point, but
You know, and I don't want to get too deep into her medical conditions, except to just ask you, has she had that assessment yet, or is that still upcoming for
I
cognition?
I think she did. I know that like she hasn't been to the doctor for that in a while, so I'm not positive.
Okay. And Ms.
But I
Hart,
know that she agreed. I know she agreed to sign it. So
okay. Ms. Hart, any input on that issue? I assume you probably are in favor of that.
Yeah, that's fine.
Okay. So yes, Mr. Hart, I am going to ask that, because that is where where kiddo is living, that you work with your mom to get that ROI signed. So Ms. Call can review that information so that we can make sure the best safety plan is in place.
yeah. Okay.
Go ahead, Ms. Call.
Well, I just was curious, Mr. Hart, if there was a plan for it. Will Eric be moving back with you? Is the plan at this point in time that he stay at Grandma and Grandpa's house, or has there been a conversation around that yet?
That's always been the plan. If there's any type of issue with him staying over there, he can come here. We have 2 spare rooms here that like I forgot to show you the basement, but we have a basement with plenty of room down there. And then we have a toy room that is my youngest son's toy room, but that it is very easily changed into a full bedroom at any point. It just needs a bed rather than a day bed in there. So
Okay.
like at any time when Eric needs to come here, when and if he does need to come here, like would just take a day to switch over a room to be completely like for him. We've already talked about that. So
Okay, thank you. I also want to acknowledge, Your Honor, that Ms. Hart shared with me that Mr. Hart and Ms. Hart, pardon me, have been doing a really great job of communicating with one another and getting along very well and scheduling visits. They're communicating really well over our family wizard. Ms. Hart's uploading all the documents she needs to be doing. Assessments are getting done. I think this is a really positive move forward for everybody involved.
Good. I think that this is good. I'm just kind of looking back at the history. So well done to both of you. I know that's probably not how this most recent iteration of reviewing a parenting plan started communication wise. So, kudos to both of you. Your kiddo's going to benefit from that for sure. What I'm looking at, I do want to do a review date for the medical records review by Ms. Call for Ms. Hart, grandmother Hart. What I also want to do is put a plan into place for what it looks like to me is before my involvement, kind of why we're here is there was originally a motion for adequate cause to change a parenting plan. And then Ms. Call was appointed and the court essentially reserved on adequate cause. So I do think at the next review date, I want to put a plan into place for how do we get to finalizing a parenting plan that works for everyone so we can actually keep this moving forward and you're not just coming back for piecemeal reviews along the way.
all righty.
Okay. Ms. Cole, how much time do you think? So my plan is step 1, let's set a review date to get an updated medical with grandma. And then we'll set a schedule in place for looking at the parenting plan kind of in total.
Well, I mean, I think it depends on if that assessment's been done or not. If the assessment's been done, I can have that wrapped up fairly quickly and we can come back by the end of the month.
Okay.
If we're still waiting for the assessment to be done, I don't know, to be honest. It would depend on the timing of that. But my impression of what's happening at this point in time is that I think these are parents who could move towards a final parenting plan agreement. It may take some negotiating and some talking. I know Ms. Hart's very anxious, and I understand why, to have in-person visitation with kiddo, and she's actually got a trusted family member moving to kind of help be a part of all of that in terms of supervisors. I know that was part of the conversation last time we met as well, was that we were struggling to find lay supervisors who would fit. And I know Mr. Hart has come to an agreement about who those people could be. So that's really good news. I would like to ensure as we move towards that final parenting plan that we really are honoring a schedule that is most beneficial to Eric in terms of transitions, especially with his latest diagnosis and his mental health assessment, that we really honor a slow process that prevents him from having too much change too quickly. And so while I know there's a lot of anxiousness around wanting those visits and wanting to be close and have overnights and all of those, I would really like to see the parents come to an agreement about what that step-by-step process looks like in terms of making sure Eric is safe through all of that. So for that purpose, I mean, I think if we're able to address what's going on with Grandma Hart by the end of the month, I would imagine that by the end of September, we could come to a final parenting plan agreement, if not sooner.
Okay. So why don't we set August 30th if everyone's in town? I know we're kind of dealing with last minute summer vacation schedules. So if that doesn't work, I'm happy to move it.
Well, to be honest with you, Your Honor, it's the first day of school that day. So that may be a difficult day.
Do we want to look at September 6th then?
That works for me, Your Honor.
Ms. Hart, does that work for you?
Yes, that should be fine.
And Mr. Hart?
Yeah, that should be fine.
Okay, so let's set this for September 6th. This will be a review and particularly related to, an update on grandmother's ability, I guess, to continue having the child reside with her. And then what we'll do on September 6th, what I would like to do is maybe come up with a schedule for encouraging, and we can do it through formal mediation, or if you all think that you could work together and don't feel like you need to go through the mediation process to come up with an agreed parenting plan. And when I say agreed, I mean, my thought is, it sounds as if there might be key points you agree on, and then maybe little things you want the court to decide, and that's fine. I certainly know that maybe you're not 100% in sync with every little request, but like you heard from Ms. Call, it sounds like you two are kind of working together pretty well right now in the child's best interest. So maybe we can set a schedule for bringing you all back to talk about this parenting plan.
Okay.
Okay. Any questions, thoughts, timelines from the parties? Go ahead, Ms. Hart.
Yep. During last court date, we were talking about starting the supervised visits. Mm-hmm. And between Mr. Hart and Ms. Call, I think we were all in agreement that the supervised visits would be starting here fairly quickly. And I believe that Mr. Hart and I had agreed that once Eric has his initial counseling session, that we should start the supervised visits. My mom has flown into town. She flew in yesterday so that she could be there for those visits. And I spoke with Ms. Call and Mr. Hart about maybe being able to do twice a week while mom's here to start those visits because, well, my mom's here to help with that.
And how long is your mom in town?
Until the 24th of this month.
Until August 24th?
Yes.
And when did counseling start? I did not write that date down for kiddo.
It hasn't actually started yet. We just got his intake, and I'm waiting for the scheduler to give me a call. But I can call him today and find out what's up with that.
Okay. And this is the grandparent that kiddo visited recently, correct?
Yeah,
that's correct.
Okay. Ms. Call, what's your input on twice a week supervised visitation while this grandmother's in town?
I'm in support of that, but I very much agree with Mr. Hart that kiddo should be in counseling actively before that begins. And I understand we've got a time frame with grandma, but I also know Mr. Hart put forth some names of people who he trusted to be a part of that visitation plan as well. And I think that's a fair request, that we make sure that Eric has adequate counseling happening, and that we have people that both parents feel comfortable with that are able to supervise those visits. I also think starting out with a shorter visit to begin with would be really important, because we've had these 30-minute digital visits that have gone very, very well. But I know Mr. Hart has also recognized that there's been some behavioral shifts, and we know that for this particular kiddo, shifts in environment, quick changes that happen to the schedule, or even new factors of things that he doesn't quite know how to communicate emotion around, or how to express concerns around. He's still learning how to even identify that he's having those feelings. And now he's actually been diagnosed with something that helps us understand that even more. And so I think I support Mr. Hart very well in saying that, can we at least make sure that we have active counseling in place, and someone who can help kiddo address those feelings and that experience. And then also to make sure since we do have other supervisors who Mr. Hart feels comfortable with, I think if timing works out, I think it's wonderful that grandma can be there. That's the trusted person that all three of these people know, and Eric trusts implicitly and loves very much, and has a great bonded relationship with. And I know he'll feel safe in her presence. But I also think it's important that we make sure all that scaffolding is still in place for him as well.
Okay. I do. Okay. And Ms. Hart, I see you shaking your head. I think that makes a lot of sense. And it sounds like, the three of you are in agreement. Again, kudos to you all for kind of understanding. I know, Ms. Hart, your inclination is probably, or your desire is, let's do it now. I want to see my kid. But, it does show the court a lot that you're willing to wait on that to get counseling started, so that that structure is in place. So what I'll do right now, because I do, I hate to say it, but if there isn't an appointment already set up, knowing wait times for getting counseling appointments for folks, I don't know if it's realistic to think that kiddo would be started before the 24th to actually say, hey, let's do visitation. So I think my oral ruling today will be, we'll start supervised visitation once counseling has started. And then Mr. Hart, if you just keep Ms. Call and Ms. Hart informed when that counseling session is, that would be helpful.
All righty.
Okay. And then certainly we can readdress that when we're back together. Okay.
All right.
Anything else for the parties today?
So let's say like when I call today, and they say like he can start tomorrow, can Eric go see her like the day after the counseling session starts? Or do we need to come back to court? Or how does that work?
Ms. Call, do you have a preference on timing with the starting of counseling versus, I think the concern, Mr. Hart, is just that there would be someone that kiddo's established with that should he want to talk about an up or down of how that visitation went, he would have that in place already. So I'm going to reverse. I was going to say I'm just going to do an oral ruling, but I will go ahead and do a bench order that states between now and our next review date, if counseling has started, then supervised visitation, let's say up to 2 times a week. And I'm not specifically going to say grandmother, but I'll say agreed supervisor, 2 times a week. Ms. Call, timing on those visits, 1 hour to start with?
I think starting with an hour is wise. Yeah. And I also think, just in terms of this question, I think I would be in favor of even if the appointment's tomorrow, Eric starting very soon after that. Because the other thing about having that counselor in place is that can actually be a resource for Mr. Hart and Ms. Hart as well. They're going to get insight into Eric's responses. They're going to be able to communicate with the counselor as well. So I think it's just about having that position in place more than it is about the court timing for me.
Okay, great. So that's really helpful. So yeah, I think what we'll just do, so you guys have some guidance, but certainly feel free to work together on what feels, right to Mr. Hart and Ms. Hart and the counselor and kiddo. But our kind of framework will be up to twice a week, up to an hour each time with an agreed supervisor. And then we'll revisit that on September 6th. Okay.
Okay.
The other thing, I don't know if I need to mention it here, like we're going camping the 16th, 17th, and 18th.
Okay.
I'm just letting the court know, like we'll be out of town, but I don't think that it's going to affect anything because he can just make the calls around those dates. There you go.
Ms. Hart, any issue,
Sorry about that.
Ms. Hart, any issue that you need the court to be involved with the, sounds like a 3-day camping trip?
No, we can just arrange calls and visits around that. That's fine.
Okay. Well, again, see, you guys are making real progress from the first time that we were all on docket together. So kudos to you. Okay. I'll get that bench order signed and then we'll see you back September 6th.
Okay, thank you.
All right.
Thank you.
Thank you, Your Honor.
All right. I'm going to recall Hart and Hart 17-300-46408. I just saw Mr. Hart pop into the waiting room and it looks like we have Ms. Kale now.
I apologize, Your Honor. I was in a courtroom in Clark County as well, so I'm hopping around a little bit today.
That's okay. That's okay. So Mr. Hart, I just called your case and I'm sorry, I saw you just connected to audio. So I just announced your case and called the number since I saw that you joined us here and that we had Miss Kale present. So this is 17-300-46408. We're on for a review hearing. I did review the minutes from the 9th of August. And it sounds like things are going really well. The parties are working well together. Hopefully that's continued, but there was some concerns about health of grandmother and her ability to be able to care for the child during visitations. And I think that's what we were set on for review for today. If that's wrong, please let me know. That's what I deduced from the minutes.
Your Honor, for the most part, you're correct. The one caveat to it is that kiddo is actually living with grandma at the time, unless that has changed since I spoke with the Hart family last. And so the concern was, is that still going to be, there were some tests that needed to be done. I sent Mr. Hart the ROI. I have not received the test back, which was part of the court's requirement that I be able to review what the test was, what the test results for grandma. So I haven't not yet heard what's kind of come of all that testing and if this is still going to be a good place for kiddo to be.
You're muted, Mr. Hart. Here, I'll ask you to unmute. Sometimes that helps.
Unmute. There it is.
There you
Okay.
go.
All right. So I did get my mom to sign that ROI. I think I might have washed it before I uploaded it. Did I send it to you? Okay.
No.
Then I'll just go get her to re-sign it. She doesn't have Alzheimer's. She does have a mild cognitive issue, but it said that there was no sign of Alzheimer's. I did have her sign the paper. And I washed it before I uploaded it. So I'll do that today. Like when we're done here, I'll walk back over there and get that done because I can just reprint it out from the last email.
Okay.
And I very much apologize for being late.
That's okay. I appreciate that. If we get that, Ms. Kale, and within the next couple days, and you're able to confirm that the placement is sufficient, I guess, what are our next steps, or what if there's any? Do we need additional reviews? Do you want to set another review for a few weeks out to ensure that we have what we need and the placement is appropriate?
That's my final concern in this matter. These two parents have done an absolutely wonderful job of working together, and Eric's seems to be doing very, very well, going back and forth between them. So for me in my position within this case, I think making sure that grandma can still caretake the way that it seems good for everybody involved. And really, I mean, ultimately that's going to come down to Mr. Hart and his family feeling like that's still a good fit. The last piece of the puzzle is just, should grandma not be able to be a good place for kiddo to be? Is there a space in Mr. Hart's home for Eric to be permanently when he's not in visitation with mom? And I believe those overnight visits are on their way. They're just around the corner, I think. Is that true, Miss Hart? I think we're getting there timing wise.
Yeah. Mr. Hart and I have talked, and we're thinking the beginning of October to switch to the unsupervised. So like through September, we'll continue doing the daytime supervised with my friend Melissa. And then beginning of October, switch to daytime weekend visits with me. And then starting November, go ahead and start the overnight, which Eric is just more than excited about. So
yeah.
And I've actually visited with Grandma Hart in person a couple times now. And, you know, she seems like she's doing really well to me. So at least from my viewpoint, it doesn't seem like there's any issues or concerns there as far as Eric staying there at this time.
Okay.
Your Honor, if the family feels like the situation is safe and good for Eric and people feel like we're on a healthy track, I don't know that we need another review. I think these two parents are doing a really wonderful job together. And I think that what's going on is really positive. Eric's in mental health treatment. Parents are doing all this great communication. I'm comfortable if you're comfortable, I think is what I'm saying.
Okay. Would you still want the ROI to be completed though?
I would like to see the test. Yeah, I would like to see the, yeah.
All right. Well, I in reading the minutes, and I saw some notes from Commissioner Carmi. She was just more than impressed by how well the parties have been able to kind of work together, figure out a plan, put the child in front of everybody else's needs and wants. And that's amazing to hear. We don't see that as often as we'd like. So I really appreciate that. So I want to commend both parties for that. And Mr. Hart, if you're willing to get that ROI done and over to Ms. Kale, I'm fine not setting a further review if both parties are comfortable with the plan that you have moving forward. Obviously, you can always return if something were to pop up, but if you don't, I'm fine not setting one.
Okay. Yeah,
Your
I'll
Honor.
go back and get that done today.
Ms. Hart?
I have a question. So
Sure.
Mr. Hart and I have been working together on getting a parenting plan together. And I turned it over to him yesterday for his final review of it and hopefully signatures. But what do we do about that? Do we just go ahead and turn all that stuff in and then get another court date, or should we set a review for that final parenting plan today?
If you have a final parenting plan that you're both agreed to, you both think this is the best final parenting plan, you can just submit that what they call ex parte, meaning you don't need to do it with a court date. And then a judicial officer would just review it and sign off on that. And then the clerk would let you know that it's been signed and you can get a copy of it. So you can do that without having to come back to court.
Awesome.
Okay. All right. All right. Well, I'm glad to hear everything is well. Best of luck to both of you. I will not set another review and look forward to getting that final plan entered.
Thank you very
I
much.
will
Right.
file a motion for discharge as well, Your Honor, and congratulations to the Harts.
All right.
Oh,
Thank
thank
you very much. Good luck.
Your Honor.
Okay. So here's where I'm at based on my review of the file. When we were last together on September 6th, it seemed to be going very well, and we were expecting agreed orders to be presented. That hasn't happened, and now I do see that Mr. Hart has filed a motion to restrict visitation and re-review the GAL findings. I haven't yet seen a response from Ms. Hart. I can't tell if she has been served that motion or not. Ms. Hart, did you receive Mr. Hart's motion to restrict visitation?
Yes, I received that. And
It's
then
very hard to hear you. I'm not sure if you can turn up the volume somehow.
is that any better? I can talk louder.
Mr. Hart, I don't know if that's from your end. There's just a lot of feedback audio.
It might be. Let me see.
Yep, that is you. So no, it's not you. Ms. Hart, is that on your end?
I don't know what it would be. I don't have anything going.
I can. Wait, hold on. I'm going to mute you just to see if it is you. Hold on. Yeah, it is you, Ms. Hart. So hold on one sec. I have you muted, Ms. Hart. I have you muted. There's a ton of audio feedback that's making it difficult for us to hear anyone else. And I can barely hear your voice. So I'm going to have you stay muted just for a minute. I think what I've heard you say is that you did receive the motion to restrict visitation. So I am going to come to you in just a minute, but because of your audio issues, I'm going to have you hold tight. for just a minute. I'm going to go to Mr. Hart and to Ms. Call. So Mr. Hart, it sounds to me like we don't have agreed orders. You have some new concerns and you want those looked into. Does that sound correct?
Well, the parenting plan orders we pretty much agreed on it. There was just a couple of errors that needed to be fixed on dates where Eric lived. And that was pretty much the only thing with the parenting plan. It just, some errors needed to be fixed. But other than that, we agreed on everything. But the issue, my main issue is that, well, it was a couple weeks ago now, my son came home and like, while we were talking about what was going on, at one point he was like, if I'm going to be spending the night at mommy's house, how do I do that if I'm not supposed to be around Kevin? Because it said in the GAL recommendations that Kevin Johnson was not supposed to be around my son. And I just assumed that the GAL recommendations was basically the court's findings because that's what she's hired to do. And when I brought this up to Catherine, she basically just said, like, I talked to Heather and she said it was basically fine. And she said I could bring this back up in the court if needs be. And so I'm just needing her to follow the rules because like we were getting along and everything was going so well because everybody was just following the rules and doing what they're supposed to. And then when I found this, and like, it's not like she disclosed that. I found it out from my son like a month after he had started going over there. And so that's just my main issue is that it said in the paperwork not to be around. And it was very, very specific, you know, and then I find out that like, not only is it around, but she didn't tell anybody.
Okay. Let me go to Ms. Call. Ms. Hart, I will come to you. It's difficult to hear you, but I will come to you next.
Good morning, Your Honor. So Mr. Hart is correct that I did in my recommendation state that no unmarried romantic partner should Eric have access to at this point. My only reason for that is because this is such a sensitive situation with Eric, and we know that dramatic change for Eric is very difficult given some of his diagnoses and some of the things he struggles with. My particular concern around Mr. Johnson is a very long history, specifically with Ms. Hart, with domestic violence as well as very serious substance abuse. At this point in time, I want to applaud Ms. Hart because she's really done a wonderful job on her sobriety. She's doing a wonderful job coming slowly back into Eric's life. And I can respect and appreciate the fact that Ms. Hart is excited to fully integrate Eric into her world and have him be back in her life. But we also know what we know about Eric is that going at a slow pace and doing this in a way that's healthy for him and with the support of his mental health professional and with the support of Mr. Hart and his wife, whom Eric has been living with for the majority of his life. Mm-hmm. I want to respect Mr. Hart's wishes that this timeline be respected in a very specific way. I also understand Ms. Hart has moved Mr. Johnson into her apartment, so I can understand that there's a desire here for this all to happen at once. But it is my recommendation that is not the healthiest path forward for Eric. And I have very serious concerns, given that Ms. Hart, I believe, has just hit her sober birthday, if I'm correct in that, for a year. And I respect and applaud that. But I think we need a longer history of sobriety for both of these people before Eric is put in a situation where he needs to adjust to not only these new relationship standards with Ms. Hart, but also with this other person in her life who he doesn't know and doesn't have a history with. Okay.
I'm just looking here at the report, Ms. Hart. I'm going to come next to you. So it sounds to me like as far as the parenting plans, we're still kind of working through that, and I can give you all new dates for that. But the most immediate pressing issue appears to be your son coming to your home now that Mr. Johnson appears to be living there. So what can you tell me about that, Ms. Hart? You're going to have to unmute and speak really loud.
Okay, is that any better?
There's still background noise, a lot of it, but just go ahead. We're just going to push through.
Okay. Mr. Johnson has been sober for over 2 years. I submitted all his certificates to both the court, to Mr. Hart, and to Ms. Call. He's been clean and sober for over 2 years. He completed the drug court program in Clark County. I turned in his parenting class certificate. He completed the 52 weeks of the DV and anger management classes. So he's, I am coming up on my sober birthday here next week for 1 year, but Kevin has over 2 years. He's been at his job for almost 2 years. The reunification process between him and I, it was a process as he completed all of those classes and everything. Eric has been.
When did Mr. Johnson move in with you?
Around the beginning of last month.
The beginning of last month. So were you aware of the court's adoption of the GAL recommendation that your child not be exposed to unmarried romantic partners without consent of the other party?
I don't know about consent of the other party part, but it was after court. And Heather was aware that we were seeing Kevin, that he was coming up on weekends at that point. And I also kept her aware of his progress. So it was after our last court that he had moved back up. It was after he completed all his programs.
Okay, but also you're talking a lot about his sobriety. What I'm concerned about is his felony DV arrests. So that's a huge concern, ma'am, for the court. I'm actually just a little bewildered that you thought this was an okay path forward, saying, well, it happened after we went to court. So, I mean, we don't have permanent parenting plans in place. This is all still very much an open family law case. And I guess I'm just trying to get from you why you think this is appropriate for your child, because I don't.
I don't know what to say. Kevin and I have a 3.5-year-old daughter together, and he's completed all those classes so that our family could be unified again. And Eric is a part of this family.
So he was arrested 2 years ago, almost exactly, for felony no contact order violation of the unlawful imprisonment DV.
Mm-hmm. And that's what he completed they entered him into the drug court program to take care of that. And that's why he went through that program and completed.
Can you understand why Curtis Hart has concerns about his child being in this environment?
Yeah, I do understand, Mr. Hart.
Okay.
I told him even, I understand, looking at the record, I would also have those concerns.
I can't, Ms. Hart, you're going to have to speak much louder.
I understand Mr. Hart's concerns, and that's why I tried to show him all the progress that had been made and everything that had been completed on Mr. Johnson's end.
Okay. Ms. Call, I am troubled by this. This is very different than what was presented to the court by Ms. Hart when we thought things were all moving forward. I understand Mr. Hart's concerns. I am very concerned. I also don't want to, normally what I would do in this situation is essentially terminate visitation until we work this out. I don't want to do that. I think this child has been yo-yoed enough, but I don't know what else to do with these concerns with a very recent history of domestic violence. Significant. We're not talking misdemeanor domestic violence. We're talking felony domestic violence.
Your Honor, I share those concerns. And the DV case was actually against Ms. Hart. She was the person involved with this issue. And she and her daughter essentially fled her relationship with Mr. Johnson. And when I first visited with Ms. Hart, and she did share with me she was having digital visitation with Mr. Johnson because he is her daughter's father. And I had asked her specifically, and I wrote about this in the report, if she was still engaging with Mr. Hart. She said she was. And that's what led me to make the recommendation that Eric not have to have a relationship with unmarried romantic partners, specifically because of the concerns that you're bringing up, Your Honor. I have very serious concerns about this as well. At this point in time, I think it would be very hard on Eric to go back to not being allowed to see his mother. And I have concerns that Eric would not understand why that's happening. But I do think either a once a week visitation or even a supervised visitation may be appropriate until Mr. Hart feels that there is enough trust established that Eric can safely be in this relationship. It is true that he has a younger sister who I think he should have access to. They have a bonded relationship that I think is valuable. And I do believe that a bonded relationship with his mother going forward is appropriate. However, I think that at this point in time, we need to see that that's going to be a healthy and an appropriate relationship in a way that's safe for Eric.
I agree. Mr. Hart, what is your hope here? What are you feeling comfortable with?
Well, I feel like I agree with the whole like unmarried partners thing, at least for like, you know, like I would imagine like 6 months, because he doesn't really know his mom yet. Like he's just getting to know her. And it's for those specific reasons, like everything you were talking about, like they had to crawl out of a trailer window with her baby, according to the paperwork.
Yeah, I
And
understand.
that's like, I just don't want my son to ever have to be put in any type of situation where a stepchild annoys a stepfather, you know? And so like, I also don't want him to not be able to see his mom, because he's doing very well. Everything's going very well. I was under the impression, like I've been told by Alice, that Kevin has a mom, like he can just go to his mom's house and not be there. You know, as far as I'm concerned, like he could still totally go and hang out there as long as Kevin's not around. Like I thought that he wasn't. And if he's not there, because Eric's in this school program where he's going to like in a leadership club, and so he needs to get like a different ride besides the bus in the morning. And so he was going to be going over there on Wednesdays. We switched it to Tuesdays so that he could spend the night and then go to school from her house, because she's just right down the road from his school. And she came and she picked him up this morning and drove him over there, which is great. But like, I'm like, if Kevin's just not there, like I'm fine. I just need the courts to tell me that he's fine. If he's fine, if he's not fine, I don't really know what to do.
Ms. Hart, my inclination is to issue a bench order that allows you the continued visitation as is, but the stipulation is that Mr. Johnson cannot be at the home when your child is there. Can you make that work?
I'm sure between me and Mr. Hart, we can figure something out. That's what we've been doing. And Mr. Johnson works full time, so a lot of times he's at work anyway.
Okay.
So I'm able to figure something out until maybe we are able to get this reviewed again once, I don't know if he's reappointed, and she can look into, I don't know, verifying his, you know, completion of classes and everything that was required for him to come back with me and my daughter.
Yep, I think that is a good idea. What I'm going to do now, we'll set a review date on this to allow Mr. Hart. I don't, Ms. Call, are you at your cap with this case? I'm not sure where you're at.
I am. I'm beyond my cap. It's a county pay case. I actually went beyond the cap on this case, but if Your Honor feels it appropriate for me to remain involved, I'm happy to do so.
Okay. I am, and I will approve additional hours and monies for this case. I think it's important in this unique scenario, and you can send that any type of request for fees directly to me, because I know why I'm making this ruling and why I'm requesting additional hours. It is for the safety of the child. I'll know specifically with felony DV cases, typically there's a 5-year probation period where a court is monitoring. So I really am just not comfortable right now with anything other than what I'm going to order, which is at least until our next review, that Mr. Johnson not be present when the child is visiting Ms. Hart. How far out do you all want to review this?
Well, Your Honor, given that we're coming into the holiday season, and I will confess my caseload is quite stacked at the moment. If we could get into the new year, I know that's a long wait. I know it's a ways out, but I want to be sure that I can actually give this case my attention.
Yeah.
If it's possible to get into January, that would be very helpful for me. I assume at this point I'm going to need to do some interviews with Mr. Johnson and spend some time with Eric. And so I just want to make sure that I can do the appropriate investigation.
Yeah, I'm thinking January, let's get us a little bit past the new year, January 10th. Would that work for the parties? That'll be a Wednesday. Well, are they keeping this docket Wednesday at 9 a.m. in 2024?
Well, and just so you know, Your Honor, I do have a review hearing that morning in Clark County.
Okay, so we'll pick a different date.
I'm available on the 17th if that works for everybody else.
When will it be? Oh, it is still going to be. Okay. For now. Now, if we change, 2024 brings in docket changes, we'll certainly advise the parties. But for now, let's set this review for January 17, 2024. I wrote 2023. 2024 at 9 a.m. That'll still be the Wednesday Zoom docket. And then I know we had the orders, the agreed orders. I would probably say, that the court is going to want to see this further investigation before we do any sort of final orders. So I would hold tight on those for now.
Okay. And would Your Honor appreciate an amended report, or would you just like a verbal review?
I'm fine either way. Probably I'll leave that to your discretion, depending on how in depth, the interviews go and the information you need to get to the court, but I'm fine either way.
Okay. All right.
Okay. We'll see you all back on January 17th. Anything else the parties need from me?
I don't think so.
Okay. All right. We'll see you back on January 17th. You're free to log out.
Thank you, Your Honor.
Thank you all.
Next matter I have is Curtis Hart and Catherine Hart, 173464-08 is the cause number. I'll see if the parties are present. Curtis Hart, are you here?
I am here.
Okay, good morning to you, Mr. Hart. And is Catherine Hart here today?
I'm here.
Okay, welcome to you, Ms. Hart. And I see Ms. Call is present. And did I pronounce your last name correctly, Ms. Call?
Typically it's Kale, but I will tell you, I don't correct anyone because that German spelling, it just is what it is.
Okay. All right. Thank you, Ms. Kale.
You bet.
So she's the guardian ad litem. She's present. I hadn't noted that we're here today or related to hear from Ms. Kale regarding the presence, I believe, of Mr. Kevin Johnson during visits and any other additional information that Ms. Kale wants to share. So I'll turn the time to Ms. Kale.
Okay, thank you, Your Honor. Good morning. Yeah, so I have spent quite a lot of time on the case at this point. I've gotten to know Eric. We kind of thought we had come to a conclusion on this case. I had submitted a number of recommendations to the previous commissioner who was working on this case. She did speak out loud in court that she wanted to adopt my recommendations. However, that didn't go into the clerk's notes. And so Mr. Hart, there was never another final parenting plan filed adopting those recommendations. And so we ended up in this sort of gray space. Mr. Johnson moved in with Ms. Hart, unbeknownst to Mr. Hart or myself. Mr. Johnson was the subject of some very serious domestic violence issues, very serious substance abuse issues. He did complete drug court in Clark County. He has now, I believe, just over 2 years sober. Ms. Hart felt like this was a good enough reason to bring him into Eric's life. She felt he could be safe. Also, Mr. Johnson is the father of Ms. Hart's second child. And so wanting to bring the family together was Ms. Hart's intention, which I can appreciate. However, one of the recommendations I made in my guardian ad litem report is that neither parent introduce Eric to a romantic partner unless they were legally married. I was particularly concerned about Mr. Johnson because I had information that they were still having contact and that Ms. Hart's intention was to reconcile with Mr. Johnson. My intention in that recommendation was to prevent introducing Mr. Johnson to Eric at a very fragile stage in Eric's reunification with his mother. We had many years go by where Eric had no communication with Miss Hart and was separated from her. My concern is the history of substance abuse and domestic violence. To Ms. Hart's credit, she herself has a year of sobriety and has been doing very, very well. She's been very forthright with me. She's very communicative with me. And we've had several conversations in which she's made it clear to me why she wants Mr. Johnson introduced. After spending some time with Eric, after Eric has had some counseling and is working on reunifying with his mother, I stand by my recommendation that we allow Eric to continue that process and become more stable in the world of his mother at this point before we introduce new partners, particularly partners who have a history of having very dramatic effects on this family negatively. I appreciate very much that Mr. Johnson is Ms. Hart's, the father of Ms. Hart's second child. I appreciate very much her desire to bring this family together. But what we know about Eric's diagnoses and his neurodivergence is that moving at a slow rate of pace, allowing him to adjust on his own time is how we see success with Eric. He has started to improve dramatically in school. He's very happy to have this communication with his mother and have these visits with his mother. But my concern is that introducing Mr. Johnson at this stage could deeply impact his ability to keep continuing forward in that growth. Further, there's some concerns around Ms. Hart in terms of her housing and Mr. Johnson living there. I think there are some things here that need to be seen through to the other side before we start bringing him into Eric's world as well. I also know Mr. Hart has some very serious concerns that I think would be fair to hear him on if you're comfortable with that, Your Honor. But that's where I'm at with this case at this point.
Thank you, Ms. Kell. So, Ms. Kell, you mentioned your primary efforts were related to Mr. Johnson and how that impacts on the son, Eric. And your recommendation is to hold off on having him be in the home, being exposed to the son, unless Ms. Catherine Hart is married to Mr. Johnson. That's kind of the gist.
At this point in time, yes. But the fact that this has happened as quickly as it did gives me more concern. Ms. Hart has mentioned to me that they consider just going and getting married. So I'm concerned that the intention of that recommendation is getting lost. The intention of that recommendation is that Eric not be exposed to romantic partners before he's ready. So I think the language of that recommendation on my part should have been adjusted. My recommendation at this point is that he not be exposed specifically to Kevin Johnson and that he have time to reunify with his mother in a stable way over a long period of time before we make that adjustment.
Thank you, Ms. Kell. All right, we'll hear from Mr. Hart and then from Ms. Hart.
Mrs. Kell said basically like pretty much most of it. This was a big concern to me because the way I went about finding out about it was just in a casual conversation with my son. He was asking about, because he knew that he wasn't supposed to be around Kevin, and he asked at one point, if I'm not supposed to be around Kevin, how do I spend the night there, or something to that effect. And I was like, well, what do you mean? And that's how we found out. It's not like she told us that he was to be there. And then almost immediately upon bringing it up, she said, well, the judge said I can bring this back to court if I need to. She takes the words from the GAL and like twists them up and puts them out of context to where she's saying like she said this, and it's just a whole lot of mess. And I'd rather it just be, I guess, more plain than it already was, because it already said not to be around, and she just went ahead and just decided not to listen to that part. So it's my main concern is everything was going really well because everybody was following the rules that were just plainly laid out, and then all of a sudden they weren't. And then when all this started, the last commissioner asked Catherine if she could, I'm not exactly how she put it exactly, but it was like, can you accommodate Eric to come over and visit and not have Kevin Johnson around? And she said, instead of just saying yes, she said, I'm sure we can work something out. And instead of just having Eric come over for the weekend visits like she's supposed to every other weekend, she only sees him on Saturdays when Kevin's at work. And it's pretty much completely dependent on Kevin's work schedule when she sees him. And at one point, before the holiday started up, I was letting him go over there on every Saturday because she was only seeing him a little bit. And this happened for about 3 weeks, I think. And then suddenly something happened and a conflict came up in the schedule. And I'm like, well, it's actually my weekend. He's going to come with us. And she's like, well, I get him every Saturday. And I've been getting him every Saturday. It's like, well, you don't get him every Saturday. Like, you have him every other weekend. You're choosing to see him only on Saturdays, though. That's up to you. Like,
And Mr. Hart, that's based on the 2017 parenting plan?
And the parenting plan that we were going to turn in right before she moved Kevin Johnson in, because we had agreed to a parenting plan, and I was just a couple of days, like, I just had to fix a couple of spelling errors basically and a couple of date errors on it to turn it in. But then we found out that Kevin moved in, and then all this happened, so it never got turned in. But
Okay, so we're operating under the 2017 parenting plan. That's what's in place currently.
currently still, yes.
Okay. All right, and so your request at this point, you're in agreement with Ms. Kell's recommendation that there'd be no contact between Eric and Mr. Johnson until a reunifying counselor indicates that he's in a position where he can have that contact?
Yes. Sure. Yes.
Okay. All right. Thank you. Ms. Hart, I'll hear from you.
Okay. And Your Honor, at this time, because of my conversations that I've had with Ms. Kale, I also feel that it's important that Eric and I have the time to strengthen our relationship before we reintroduce another parenting figure in his life. So I do understand that at this time. I am comfortable with having him on Saturdays. If his dad wants every other Saturday, then that's fine too. I have not had a chance to speak with Eric's counselor yet. I'm still waiting on a phone call back from her. But like I said, I do agree that some time needs to happen before anybody is reintroduced to him, specifically Kevin. I asked the court that after a year that we begin to slowly introduce Kevin into Eric's life and to work on a whole family here. And I think it should be a slow introduction after that year that Eric and I have with our in-person visits. After that year, I think it would be appropriate for visits to be where my mother would be present. She'll be moving back here from Nevada here in a couple months, but where my mother would be present to provide any additional support for Eric. I know Mr. Hart has been asking that no contact be made for a total of 2 years. But I think a year with me and Eric having our time to build our relationship, and then a year with the support from my mother during that introduction period for a total of 2 years.
Okay. All right. Thank you, Ms. Hart. So, children are individualized, when they're ready. I don't know. They might be ready sooner. They might be ready later. It sounds like your son is making progress, and we don't want to interrupt that. And it sounds like there's an agreement by Ms. Hart that she understands that it's important that he's ready when he's ready for that introduction to other potential figures within the home. So I'm going to adopt that recommendation by Ms. Kell, also supported by Mr. Hart, and sounds like supported by Ms. Hart, that there be no interaction between the son, Eric, and Mr. Kevin Johnson until, according to the counselor, he's ready for that. And then the focus will be now, between now and then, continuing to strengthen the relationship between Ms. Hart and her son, Eric. The parenting plan from 2017 indicates that Ms. Hart has parenting time on Saturdays from 2 to 8 every other week. That's the order that's in effect. That's the order that controls, and that continues at this point. I'll do a bench order today that lays out that there's not to be any contact between Mr. Johnson and Eric unless specifically provided by the counselor. And then if that's provided by the counselor, then there need to be noted up so the court could review that. before any contact occurs. So it's not to be unilateral by any party introducing or having contact between Mr. Johnson and Eric unless the court specifically says that's okay after receiving input from the counselor. So that's where we're at, and what the timeframes are as far as Eric's improvement of his relationship with his mother. We'll have to just wait and see how that goes, and hopefully it improves and is good. So that's the court's ruling. I'll ask the parties if you have any questions about the ruling. Ms. Kell, any questions?
Not at this time, Your Honor. Thank you.
Okay, Mr. Hart, any question?
Not that I believe so.
Okay, Ms. Hart, any questions?
No, Your Honor, thank you.
Okay, all right. Thank you all for your input. I appreciate that. I'll have that order. I don't think it'll be filed today. I've got a pretty busy afternoon. So hopefully by the end of business tomorrow, it'll be filed and you can get a copy thereafter.
Okay, thank you.
Okay.
Thank
all
you, Your
right,
Honor.
That'll conclude the efforts for today. Thank you.
Thank you.
They have not returned to court since the hearing in January. It's now been nearly a year since they were in front of a judge with no sign of any new motions, so it seems like Mom is behaving herself and following the recommendations of the counselor, or I would have expected this father to file a contempt motion if she does not. I really hope Mom is putting her children first these days. I'll keep an eye on Odyssey and update the case if anything big happens. Thank you for watching.